Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
A recent settlement involving IBM has drawn broad attention across the federal contracting community, drawing attention well beyond the specifics of a single company. For many contractors, this case raises questions about how workplace initiatives intersect with the long-standing employment and contracting rules. Joining me with more details is Sheila Abron, partner at Fisher Phillips and chair of the firm's government contracting, compliance, and reporting practice group. Sheila, welcome back to the show. It's great to have you here.
Thanks. I'm excited to be here.
Let's talk about IBM and their recent settlement. On the 10th of April, they reached a $17 million settlement over their DEI programs with the Department of Justice. When you think about this case, it's really drawn attention well beyond the IBM community itself. Why do you think this case has gotten so much notice among federal contractors?
I think it's gotten so much notice among federal contractors because it is the first time we've seen the Trump administration have enforcement along DEI efforts. Starting back in January of 2025, it was January 20th of 2025, we saw several executive orders and a primary one for federal contractors along the lines of DEI initiatives and quote unquote what it might mean to have illegal DEI. And lots of pronouncements from the government, but this recent settlement is one of the first times we're seeing actual enforcement following through from that. Another reason that this has captivated some attention is because of the time scope of the settlement. It goes back to 2019, which is a bit unusual in terms of enforcement when we're talking about compliance, especially in the federal contracting space. Typically, you're going to see whether it's an executive order or some kind of contract modification from the federal government, you'll see that on a prospective basis. But the IBM settlement reaching all the way back to 2019 is really interesting in terms of scope.
What specifically were the terms of the settlement?
So the big thing, the other headline kind of grabbed that is the settlement was over $17 million. So we've got that piece of it that IBM has agreed to pay back $17 million to the federal government. And then there are also some non-monetary terms in terms of things that IBM has agreed to do to comply with the terms of their settlement in relation to, stopping some of their DEI initiatives and those things that the federal government found to be kind of problematic during the investigation.
In the course of this settlement, though, IBM did not admit any wrongdoing, right? Is that something that other contractors need to take into consideration?
Yes. And I think that is something that you would typically, obviously working with legal counsel, be talking through and negotiating that point within an agreement. But yes, IBM did not admit any wrongdoing.
So contractors may still have workforce initiatives that seek to diversify their workforce. Where do those programs intersect with existing employment law and federal contracting obligations now?
So that's a really good question, right? So federal contractors have always had Title VII obligations. So Title VII of the Civil Rights Act has said, we are not going to make any employment decisions based on any kind of protected characteristics, whether it's hiring, firing, promotions, that sort of thing. That's always been the case. And federal contractors have had an additional layer of requirement there through the rescinded now Executive Order 11246 that had required that federal contractors also not have any discriminatory activities based on race or gender or some other protected characteristics. And now we see, though, in the furtherance of some of those non-discrimination activities or the outreach associated with them, we see those clashing with the executive order and the executive orders from the federal government, as well as the guidance that we've seen from EEOC, Department of Justice, and now what we can glean from this IBM settlement along the lines of how those initiatives may be in tension or conflict with what the current administration's view on those activities looks like vis-a-vis Title VII and other civil rights laws.
I'm speaking with Sheila Abron. She's a partner at Fisher Phillips. Sheila, how do company staff and company leaders then balance the requirement to comply with laws and the tension that the executive orders and DOJ's enforcement mechanisms create?
So one of the things I think that is critically important is to remember that you should be following law. So you're right, Terry, when we're thinking about that, that should be your North Star, is that we want to be compliant in that aspect. The other thing that we can glean from this is that the guidance that we have seen coming from the federal government can provide some informative information as to things that might be considered problematic should an employer find themselves in an enforcement action with the federal government. So looking towards that guidance and then looking internally to see how their programs, policies, or practices may diverge or align with that guidance and making, appropriate business decisions that are making sure that they're legally compliant, but also staying kind of true to whatever their company culture and priorities are.
Sheila, in your experience, when laws and guidance are in conflict, does that typically stem from the goals of the program, or is it really about how the eligibility criteria and documentation are structured?
So that's a really, really good question. And I will kind of pull this back a little bit. And I think about DEI, and I think about the implementation of it and being able to see the broad scope of the way that different companies implement it. I think it goes to more the implementation aspect more so than just the pronouncement, because it's the how that we're going about doing things. The why is important, but the how we're going about the implementation, how we are trying to get our priorities done, that is what can lead to kind of some problems or some divergence in the activity.
You've talked about some compliance steps that companies could take right now in light of the terms of this settlement. Walk us through what those would be.
Yeah, absolutely. So the first thing, if you haven't already, doing an inventory of what your DEI activities are. And I would also, given kind of the temporal scope of this settlement, look at what they've been historically with an eye towards what that might look like to you should, the DOJ or some other enforcement agency come knocking at your door. I would recommend you working with legal counsel on that from a privileged perspective. Also being thoughtful about any forthcoming initiatives that you might have in place and thinking about how those may be viewed when we're talking about doing our program. So doing an audit of our prior programs and doing an audit of any future ones that we're doing, and thinking through having clear documentation as to why we're doing certain things. If you have demographically driven performance indicators or hiring practices, that is definitely something that is in the higher risk area and something you definitely want to review in terms of how that is actually playing out in your day-to-day practices. But I think if you consider and think about the goal of our civil rights laws, our goals to providing equal employment opportunities, if you think about your programs through that lens, that can really be a strong guidance for you. If your program or process does not provide equal opportunity for every one of your employees, then we might have something that you want to look into and dig into. But if you stay with the tenet of our goal is to provide equal opportunities for all, and we're going to be making these merit-based principles, that should be a really helpful and strong North Star for you.
That's really helpful guidance. And Sheila, this was, as you said up front, the first settlement under the new Civil Rights Fraud Initiative. Are you watching others in the pipeline, or what should the contracting community stay tuned to on this news front?
I think the contracting community should definitely stay tuned to this because we have seen this settlement. The Civil Rights Fraud Initiative is not going away. That is going to continue to be an enforcement mechanism. We've seen other litigation that is coming out from the EEOC. Most recently, we saw that there has been another DEI executive order along with some forthcoming contracting clauses. The FAR Council released what those contracting clauses look like around DEI that have flow down provisions. So contractors are going to start having communication from their contracting officers around contract modifications. So this area is very ripe and something to be very focused on. I will say that executive order and that FAR account with the corresponding FAR Council information from March 26 is currently the subject of some litigation. And so staying abreast of all of the legal trends that are going on here and the guidance, and then also making sure that the people in your organization that are dealing with the federal contracts and dealing with your contracting officers are also communicating with the individuals that are executing in your talent, in your DEI, in your hiring, however you're structured, making sure that those folks have some synergy and communication is going to be critically important as we embark on this kind of new frontier of enforcement in this space.
I've been speaking with Sheila Abron. She's a partner at Fisher Phillips and Chair of the Government Contracting, Compliance, and Reporting Practice Group. Sheila, thanks so much for joining me.
Thank you, Terry. It's been a pleasure.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts.